There's only one item, so you can just
Yeah.
Should be pretty straightforward.
worry too much about it.
Yeah. Whatever you want. Can I borrow? No, I have. Baron just decided to steal it. The special meeting to vote notice to actually hear the ordinance at the May 12th. Okay. Why is that an expired? For like everything? For new ordinance. Yeah. 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 So interesting. Because a lot of cities require a notice, but they don't require a vote.
That's how it was like
Okay.
when I started here.
All right. Thank you.
One night I need. I'm gonna find some. Do they have water for self here or anything? I've got to find something.
Okay, we'll get started in just a minute. We're waiting for one, a red line printer. So as soon as we get that, we'll be in good shape. I told you, it'd all get done when Amalia was ready to get it done. I told everybody that, so I'm glad. Thank you very much. Boy, she had a lot of, she put so much red ink in here, there's probably hardly any black ink left. Boy, she's hard with it. Yeah. We will call this meeting together, call it to order today to discuss the action item we have today is proposed ordinance 22-07 and whether or not to advertise and to hold a public meeting considering proposed ordinance 2207, amending chapter 27 of the Roswell City Code relating to cannabis. And so that's the purpose of today's meeting. If the clerk would please call the roll.
Counselor Arnold,
Present.
Counselor Oropesa. Here. Counselor Heldenbrand,
Here.
Counselor Halverson,
Present.
Counselor Sanchez. Here. Counselor Corn. Here. Counselor Moore.
Here.
Counselor Corn Best. Here. Counselor Foster.
Present.
Counselor Perry.
Is it?
Mayor, you have a quorum.
Thank you, ma'am. And the mayor's here too, so we're all lucky. Okay, so for the proposed item 27, if we could start off, we have, as the only individual we have signed up to speak for is Mr. Jesse Hunt. Would you care to?
Mr. Mayor,
Yes.
if we could approve the agenda at,
Oh, I'm sorry.
I know, that's okay. Mr. Mayor, I make a motion that we approve the agenda for this special city council meeting this evening with the one action item of the proposed ordinance 22-07 for advertisement.
I'll second.
Thank you. We have a motion by, a motion and a second to approve the agenda for today's section. Is there any objection, or please vote? You wanna-
Mr. Mayor,
Yes, ma'am.
can I get who the second was?
Oh, I'm sorry.
Ms. Arnold, thank
Councilman
you.
Arnold. Sorry. Would you rather have a roll call vote or just? Well, no, I mean, so it's a motion and a second. All in favor?
Aye.
Opposed? None. Do you have an unanimous decision to approve the agenda? Okay, now we have our action item for proposed ordinance 22-07. Mr. Jesse Hunt, or I say Miss Jesse Hunt, excuse me.
That's okay. I'm used to that. Hi, I'm Jessie Hunt. I'm with our Greenleaf, and I just really want to thank you all for all of the work that has gone into drafting all of these ordinances. We've been really proud to be a part of the community here and appreciate this newest effort to really, understand and accept that the companies that have been operating as medical dispensaries here in Roswell have been really good partners to the community, and we just want to really continue to be that. We know that with expansion, there are, with the expansion into the adult rec space that it's caused a lot of questions in a lot of communities across the state, and that's totally understandable. I think what we are really excited about is that we have been good partners, and we want to keep doing that. With the expansion into adult rec, whenever that happens here in this community, we look forward to bringing more revenue into the community that then will also help support services. And we are a really open book at our Greenleaf. I know that our colleagues from SWAP offered to give a tour at any time. We are also happy to give you a tour and just kind of show you all of the safety measures that are in place and all of the steps that we would take to be really good partners in our communities. So please just consider this an open invitation either now or once we do have adult rec and you can walk in on your own. And I just really want to thank you all for the time, and I'll be around even if there are questions afterward or whatever. I'm happy to talk about how we really view this expansion, but I thank you again and really hope that this ordinance gets adopted to be heard in 2 weeks. Thanks so much.
Thank you, Ms. Hunt. Are there any questions of Ms. Hunt? Name and address. She said where she was from, I believe.
I actually live in Albuquerque, New Mexico, but I work with all of our stores across the state.
Thank you, Matt. And Ms. Hunt, I'm sorry, but I was named after my great-grandfather, Jesse Zephaniah Schultz, and my niece is Jessie, too. So, I mean, I don't know how to win.
It's all good.
I can't
I
win,
get it
but
all the time. Just don't
thank
call
you.
me Jessica. Just call me Jessie.
Thank you for your invitation.
Thanks.
Okay. Is there any other public comment? Is there any other public comment? Seeing none? Okay, we'll go to action item on proposed ordinance 22-07. Parker, would you look here to explain what we have here?
Good evening, Mayor and Council. Procedurally, would you like to have a motion on the floor before the presentation or the other way around? However you would like to proceed.
Representative Corn, or excuse me, Councilor Corn has asked that you do the presentation first.
Yes, sir. Okay.
Thank you.
So I do apologize to the members of the legal committee and those who were here before. I don't have a lot different to say, so I'm going to go through some of the same things again. I don't mean to bore you, but I think it's important. And for those that were not here for legal, I'm going to go over some of the same areas, but also talk about what was recommended by the legal committee and the document you have in front of you, just to kind of compare those. So this is proposed ordinance 22-07, which would amend chapter 27 of the code. Chapter 27 is the cannabis ordinance. It was adopted back in August, as some of you will recall, and then twice amended in October and in December. It sets forth all of the city's regulations with regard to cannabis, from personal use all the way through commercial sales and industrial uses. Everything that you can do is addressed there, or has the ability to address that if you want to make amendments going forward. As of right now, commercial cannabis just has, this is like a really like 50,000 foot view of the process, but there's four major parts to it. A new cannabis business is going to come in, they're going to submit a pre-application review to planning and zoning. Once that goes through, then they take a proposed zone change and a CUP to Planning and Zoning Commission. Planning and Zoning Commission, in this situation, unlike normally where they can approve or deny at their level, they, in this circumstance, only recommend up to City Council, who retains the final authority to approve that zone change and conditional use permit. Once they've got the conditional use permit, they go back to Planning and Zoning and get the final piece, which is the regulatory permit, which kind of gets into the nitty-gritty of what's your business plan, what's your site plan, all of that kind of stuff. And then once that's granted, they are the new business is ready to go. Just to help you understand the zone change, we've discovered that you can do something called a floating zone, which is an idea that it's part of an existing zone, but it kind of remains theoretical out there. And then when a particular application comes in and that application meets the requirements, it can then land on a particular parcel and become the zoning of that parcel. So we've got two types, CCAN and ICAN. CCAN is commercial cannabis that's allowed in the C2 district, and then ICAN, which is allowed in the industrial I2 district. And so obviously if you have CCAN, you can do sales, retail stuff, and if you have ICAN, you can do manufacturing and those type of activities. The big issue that I think has brought us here today is the issue of non-conforming uses. And I discussed this a bunch at legal, and again, I don't want to bore you, but I think it is important to understand how this evolved to where it is today. We do already have ordinances in our zoning code that deal with so-called non-conforming uses. Basically, the idea is, let's say that you're a business and you're in like a C2, let's say, and then the city comes along and rezones it to residential. If you would then be in the wrong zone. even though it's not your fault, you've been there forever. So the concept of the non-conforming use is to allow that business to proceed and continue as it had before, but only in that use. So when the Chapter 27 was adopted, that was the model that was adopted from the zoning code. Literally, the exact same provisions were taken out of the zoning code and put into cannabis to apply to those businesses which were involved in medical sales as of the adoption of the ordinance. They were treated like non-conforming uses in other contexts. The upshot of that was that those businesses were strictly limited to only those types of activities which they were engaged in on the day that the ordinance was adopted back in August. So there wasn't any recreational sales at that time, which meant that those medicinal shops were then, as I said, illegal, frozen in amber. They could never change, right? If they wanted to continue as non-conforming uses. They have the option to go through the process like a new business, and then they become just like any other cannabis establishment, but they have to do what we just saw, which was get a zone change to a CCAN or an ICAN, and then get that conditional use permit before proceeding to an operational permit. That's the lay of the land today with regard to those existing uses. So my plan is to go kind of section by section through this ordinance and kind of talk about each of the proposals. This one, fees, there's two things that we're considering doing here. The first one is to basically just tell the people that are interested in doing this where they can find the fees. It is sometimes the case that, you don't necessarily know. Of course, all the resolutions are on the city's website under the city clerk, but this would be more like, I know that I'm looking for cannabis fees, and so right there in the ordinance it says you can go to the community development department and find those fees posted there. The second part is a bit of a kind of a new idea, and basically the idea is that when the city goes ahead to propose amending this fee resolution, they would send a notice prior to the adoption or consideration of adoption of that fee resolution amendment prior to that, so that would give the opportunity for those businesses to put input into that and be a part of that process. The thought process here, one, I wanted to kind of address some of the comments that were made at the previous city council meeting that, had the cannabis industry been brought in on the front end, the rollout of our cannabis ordinance could have been smoother, less surprises, and they would have had the input of the people who are actually regulated here in creating that system. So this is kind of an attempt to address that comment and create a mechanism to bring the industry in on the front end when the idea is we're going to change what we're doing, particularly fees, and we're going to let you know before we do it, and then you'll have the opportunity to comment on that and put your input into it. This is not something we do in other contexts. There's not really another industry which we do this for. I will say that the flip side of that is that there's not another industry that we regulate in this way. So basically, when we issue resolutions for fees, it's like business fees, and all the business applies to all the businesses, right? Fee for a variance. Anybody that wants a variance, one fee. It affects everybody. This is kind of a unique circumstance we have with regard to cannabis, where we've picked this industry out of the market and created a particular set of legislation that apply only to it, and all of the fees that are associated with that. Now, that was not done out of any animus towards cannabis, but rather concerns which even the lady who was up here a minute ago said, yeah, there's a lot of questions about how this is going to be rolled out. And so in answering those questions, we've created this regulatory process of the zone change, the CUP, the regulatory permit. And so with all of that unique oversight comes all the fees that are associated with that, because of course, all of that is staff time, staff resources, and in a cost recovery type of approach, we say, okay, all of that needs to come back through those fees that are associated with that. So what I mean to tell you there is that the cannabis industry has a unique input into this because they're the only ones affected by it, unlike a normal situation where it affects the whole community. So that's where the idea is they get a unique notice because they're only ones that are directly affected by it. That's the idea. Okay. This section was actually recommended by legal to be struck, and you'll see it's a little bit confusing. There's a comment about all the red. Here's why. So what happened is when we offer to amend a section, in one of our ordinances, we put the whole section in there. We don't take like pieces out necessarily, right? We have the whole section, and then we underline, here's what we're changing. So now what was recommended by legal is to just, that was going to be added, a definition of cannabis into the cannabis section. So now they've recommended that not be added. So effectively, we don't need any of this because we're not changing it, right? We're only going to put things into this that we're changing. So if we're not changing anything about additional definitions, just take it out altogether. We don't need to mess with it, right? So that's why this is, so in the proposal, that the red line version that you've got from legal, Section 2, 2712 additional definitions, the whole thing is just removed because we don't need to mess with that one, okay? So that's why that is the way it is. But just for your understanding, the proposal was that we would add a definition of vertically integrated cannabis establishments into our definition section. I think that that's not necessarily necessary because, as I said, in another section there, we actually incorporate all state law definitions by reference, which allows us to keep up with them automatically. We don't have to go back and check whether or not they've changed their rule. We're automatically up to date because we just adopt by reference their stuff. And it also simplifies our ordinance by not having to put a whole bunch of stuff in there that is somewhere else. So the recommendation out of legal was just leave that section alone. We don't necessarily need that right now. Okay, so then the other request that we heard at the city council meeting was, can we get some hours of operation that apply citywide to all the cannabis retail businesses? And so that was this next two sections, which are 27102 and 27132. What we're doing is we are putting operating hours. So 102 is actually just a whole laundry list of different standards. And so subsection K there is a new subsection of that, which would add operating times. And I had originally put in there 10 to 8 Sunday through Thursday, and then Friday and Saturday 9 to 10. But the request out of legal was go 9 to 9 on weekends. And so you'll see that in the red line version there. And then operating times for on-site consumption would similarly be limited to the same time periods as retail sales under this proposal. Okay, so now let's get to the proposed changes to the non-conforming uses. 151 is the authority to continue operations despite the fact that they are no longer in conformity with the zoning. Now, as I said, the model that we've been using is the traditional non-conforming use, which we have in the zoning code, which like the trapped in amber thing, right? They're frozen in time forever. They can never change. That's not made up for this situation. We do that across the board, just like in the bakery that gets rezoned residential. They can't expand their shop and now have, a dining area, or change from, bakery and now we're going to add hot food. In all of those would eliminate their existing non-conforming use exemption, and then they would have to go back and get zoning fixed, right? So the original model was treating that exactly the same for those existing medical facilities that were in effect in operation as of the date that this was adopted. So the change would be to go from that model to treating the existing cannabis businesses as if they had already gotten all the paperwork done for their zone change, right? So they would effectively be treated just like a new business that had actually done all this stuff, gotten their zone changed, gotten their conditional use permit, and they're ready to, the last step is to get that regulatory permit. And so basically they would jump ahead of all of that stuff and go straight to the regulatory permit to begin recreational sales and move beyond just the medicinal, which they were locked into under the old model. So that was kind of the paradigm shift that I thought about it when I heard what everybody was saying, was we're going to go from that traditional model to an as if. We're going to treat them as if they were properly zoned. And one of the corollaries that then came to my mind was, if we're going to treat them as if they were properly zoned, a properly zoned entity, assuming it could meet the other requirements, could apply for, and if it met the requirements, obtain on-site consumption permit. So the idea is that if we're going to treat them just like that, then they would also be eligible for the same types of activities that a properly zoned entity would. And so that was where I came up with this provision that that addresses on-site consumption. And my thought process there was I wanted to spark a discussion about it, because I think that we cannot create this without addressing it, because under the old system, of course, they could never do on-site consumption without going through the zoning process, because moving to on-site consumption would be a new use which would invalidate their non-conforming use status. So there's just no way it would even come up under the way it's written now. But by opening the door to retail sales for these entities, now we have to address some of the knock-on effects of that. One of which occurs to me is, what do we do when one of these entities walks into planning and zoning and goes, well, here's my application for on-site consumption. Well, if we don't address it, then staff is going to be going, can they do that? Whether we say yes, they are permitted to apply, or no, they're not, I think it needs to be addressed. And to be clear, they would not automatically be entitled to on-site consumption, right? They would be able to apply for such a permit. And there's restrictions on those types of activities, both in the state law and in our ordinance, that would apply to that. So that on-site consumption would they would just be treated as if they were a regular entity applying for that. Alternatively, if you don't like that model, I suggest strongly that you explicitly state so, and so then you would change it to they will be allowed to operate without the necessity of a zone change, but they shall not be eligible to apply for on-site consumption. Like, say it explicitly so that we know going forward what they can and cannot do. Okay. So this is another section that was changed by legal, and again, same thing. You're going to see a whole bunch of red, and it's the restrictions section. As originally prepared, the idea would be these restrictions are those activities which would invalidate your your non-conforming use status. And so what the idea was that we would allow potentially these businesses to expand or repair or alter on site without eliminating that non-conforming use. In other words, not having to go out to back to zoning and get zoning permission to rezone it. That would allow them to change their use without having to do that. But again, this would be something different than what we actually do with other non-conforming uses, because all of these sections are directly the same as what is in the zoning code for other non-conforming uses. So the idea from legal was, no, you know what? Let's just put those back in, because we don't necessarily know what those businesses might do in the future. And the idea is we do want to have some input into, are they going to turn into Cannabis Mart, or what was it? Some kind of huge retail store for cannabis, right? And not have any input into that at the city level. So the idea was, no, if they're one of these non-conforming uses and they're going to massively change or even change it at all, they need to come back to us and go through that process. So so they were being struck out. Now they're being left in, and no change is being offered to this section. So we just take it out, right? Because we don't need to mess with it. It's going to stay exactly the same under this amendment. So that's why in your packet you'll see it's all struck out red, because we're just going to take it out of the ordinance. It's not going to be addressed here. It's going to remain as is under the legal committee's recommendation. Lastly, this is just kind of a cleanup issue. Like I said, when you change one thing in a set of ordinances, this interwoven and complex, you kind of have to think about some of the knock-on effects. So one of those is when you talk about the operational permit, one of the things that the operational permit requires is when you come, you can't really start operating until you get that conditional use permit. And it says it explicitly there in subsection 2, a conditional use permit from the city is required before you can begin operations. Well, if you're a non-conforming use, we've just said in the section we were looking at that you're going to be exempted from zone change and conditional use permit. So now in this section, we have to kind of make it all coherent and make sense. So we amend subsection 2 of that to say, except in cases of non-conforming use, you need to get a conditional use permit, right? So that it's all consistent with itself. Because otherwise you create an ambiguity, because then it says they don't need to get a conditional use permit, they can jump straight to a regulatory permit, and then you get down to the regulatory permit and it says, well, after you get a conditional use permit, you can do this. It wouldn't work, right, for those non-conforming uses. So we have to make all those sections make sense when read together. So this one just does that, it cleans it up. If you're going to do that, then you need to do it on this side. With those comments, and I think I hit all the amendments. Yes, I did. Okay, with those comments, I would stand for any questions.
Okay, we have questions. Let's see. Anybody signed up to? Oh, I got a bingo. Councilman Perry, please.
Mr. Mayor, I don't know that, I don't know, I can't speak for the rest of the council, probably without knowing whether or not that there's it's hard to make motions to amend when there's not a motion on the floor. So I would feel much more comfortable if we could get a motion so that we would know as a council where to proceed from there.
Okay, thank you. We need a motion. Councilman Hildebrand?
I move that we move to advertise and hold a public hearing and consider adoption of proposed ordinance 22-07, amending chapter 27 of the Roswell City Code relating to cannabis.
Do we have a motion on the floor? Is there a second? Oh,
Second.
okay, we have Councilman Orpesa, but she spoke louder than you. And so we have Councilman Arnold has seconded the motion made by Councilman Hildebrand. So now we're on that, Councilman Perry, we're on that order of business. Oh, wait, we have a motion on the floor, so that's fine. So now you can discuss it.
Mayor, I would sort of like to hear from others what the council is thinking, so that I can better understand maybe some of the concerns that I may want to bring up, if there are any or not.
Okay, thank you, Councilman Perry. Now you have Council Lady Moore, please.
Hi. I had a quick question. I guess I had the 2-week notice thing. I'm struggling with that, but after I heard your explanation a little bit, but I feel like, well, when the state changes the speed limit or the law, they don't give us a 2-week notice and tell us that we need to know that we need, if we speed, we're gonna get a ticket, whether they tell us or not. So I feel like that I'm struggling with other people saying they feel like that we didn't give them enough notice and enough information. Just like it was on the front page today and everybody's here, it was on the front page a zillion times. So I struggle with providing them with a 2-week notice because I feel like no one else gets that. So, but when you said it's a new kind of regulatory thing, I thought about, I think about it a little bit. I may not be so upset about that, but I feel like they're getting special treatment for some reason, and I'm not okay with that. I'm not liking that. But I'm going to keep thinking about that one because I don't necessarily agree with giving them a notice because we're going to change something. We don't do it for everybody else. So, but everybody else is not regulated like them. So I'm going to rethink that one. And that was on my fee thing. I felt like I'm gonna hold that thought on the fee right there. The next one I had a question was this on premises,
On-site
on-site
consumption.
consumption thing. Yes. So we're not doing anything about that right now because there's no rule about that right now. That's what you're saying, but you throwing the words out there so it'll be familiar. Because I heard somebody say something. I think that gentleman said something about a lounge or something, and I heard so we'll deal with that when it comes. But you're trying to make it already on the radar. Is that what you said?
Right. So we do have a section in our existing ordinance that does address on-site consumption permits. They are at this stage, the way it's been drafted, subject only to city manager approval, subject to conditions that he would set on that. So it does that aspect does not go through city council like the zone change, but that does open the ability when there is we do have some sections that do address that. And I will also say that the state, the Cannabis Regulation state law also talks about, they can't be within the restricted area of a school or daycare. It actually says so. Even if so that's an example of something where if they said, well, we're an existing use and we're entitled to retail sales, now here's our on-site consumption request, we'd be like, oh, well, I'm sorry, you're within 300 feet of a school. You were, quote, grandfathered in for purposes of, of your retail sales, but by state law, you can't go to the on-site consumption. So that's kind of what I was talking about. There are some regulations out there that talk about on-site consumption right now. So it's not a Wild West at all.
Okay, and I think the guy said something I didn't know too. He said if you're retail, you can't have a consumption place at the same place. Is that true?
No,
is that a state thing or is that just something he knows?
Only within 300 feet of a school. is what I'm talking about. So yes, a retail establishment can, that's kind of the concept, is that a retail establishment could apply for an on-site consumption permit if they met with, so if they got the state stuff first, right? They get all their paperwork from the state, you're authorized to do on-site consumption, then they could bring it to us and say, we've got it from the state, we're not within 300 feet of a school or daycare, and we're otherwise authorized to do retail sales, here's our application, and then we would review that, and then, you know, the city manager or his designee would say, okay, well, here's kind of the conditions that I would set on that, and then you could move forward with an on-site consumption permit at that time. If
Could
you're
we say no?
not arbitrary and capriciously. In other
Okay.
words, you,
Don't be using those lawyer words, arbitrary, capriciously. Just say no.
you
Sorry.
have, so.
I know what you're saying. I understand.
Yeah, you
I
can't be, you
understand. There's a
can't be
reason.
unfair. You can't be
Yeah.
unfair.
Okay, sir, can I ask him to tell me what he said earlier about the consumer, the one with the hat, you? Yes, sir. Could you tell me what you said earlier about being able to? I'm sorry. Sorry, sir.
Will Boston, 2 Brazos Place. So the vice license, as you guys have identified, have the ability to do a whole spectrum of things, from production, manufacturing, to retail, and then finally potentially a consumption lounge environment. Well, the vice license is operated as both a medical and recreational facility. So it becomes a different situation when you have medical and recreational and try to open a consumption lounge for those conjoined operations. So for us, and I think most vice licenses, you'd have to open a completely separate retail space and apply for, from the state, a permit to open a consumption lounge. So you don't just automatically get to open a consumption lounge just because you have a retail space. It's a whole separate application, a whole separate environment and rules and all the things he talked about as far as ventilation and all these things that the state requires. So I think it's a good idea, to be honest, to put some stipulations on consumption lounges just in general for the city. I'm not for them either myself, so I don't know what those would look like, but maybe something as simple as the process for the application goes in and it's looked at much more stringently than other types of applications. You know, especially, I mean, you could probably ban 99% of those just based on the Clean Air Act and how you're gonna address the, you know, smoke getting out.
Thank you. Thank you. I guess that makes sense in the Clean Air Act, and they don't have places that where you can go down, everybody can smoke a cigarette, so why would we have a lounge where everybody can go smoke some cannabis? All right. That one, and I have one more.
Council Lady, I would just point out, I think, into the consumption thing, you have to, not all of it's gonna be in smoke. So, you know, I mean, gummy bears, you know, that's just all I'm saying, is it just, see, look, it goes both directions. Gummy bears are different than smoking. So, you know, but I don't know how you stop them from swallowing a gummy bear, but, you know, but I'm just so it looks both ways. Thank you.
Thank you. My last good thing, and I guess, I want to kind of address the time situation. I guess we weren't there, and I don't know where these times came from. I don't know. I didn't hear y'all discussion, except for your change to 9 at the legal meeting. And so I was just kind of wondering where these times, just random, you just went bye-bye. And so I was kind of wondering how you came about those times, because I'm still with the no sale on Sunday concept for me, so.
And I, as I said at legal, I do not claim to be an expert in what operating times are reasonable for a cannabis establishment. You know, we just kind of, we kind of came up with some times that, as a proposal. It's not meant to be, this is recommended as the times that are great for cannabis. I don't personally know, I don't run a cannabis establishment. And as to that, you know, we are, you know, it's certainly, I think, within the realm of time, place, and manner restrictions if you wanted to make an amendment to prohibit Sunday sales.
Okay. I don't know. There's a lot going on, so let me for my last question. We'll make a motion all at once, and I think Perry's going to make a motion. He can add them all together. so he can make them all together. So like I said, since the time, place, and manner were the only thing we had control over, so I just feel like there's an abundant amount of time, and so I'm kind of struggling with that because, I don't know, everybody deserved a day off, you know.
Yes,
You know,
ma'am.
even the man had a day off, so, they already took the other ones. I was wondering about the additions, but I saw Ms. Arnold take care of that, so I think that was my last little note. My biggest concern was about the time and then no Sunday and then, the 2-week notice, but y'all took care of that too, so, I yield for now.
Excuse me. Okay, thank you, Council Lady Moore. Next, we have Council Lady Halverson, please.
I had a question on section 27102, part I. You have no cannabis orders shall be detectable outside the permitted retail cannabis establishment. That all kind of fits in with the on-site consumption. So what happens when someone walks out of these stores and either smokes up right outside or starts chewing the edibles on the site? Is that the responsibility of the store owner?
I mean, yes, in the sense of just like the smoking, you know, the Indoor Smoking Act and you know, all of that says that the premises owner has to, you know, prohibit smoking within, you know, inside and then
10 feet
within,
is the
and they
smoking.
can be fined if they don't do what they need to do to police that.
Okay, so they can lose their permit if they let someone either eat the edibles or smoke in their parking lot.
Yeah, I think that if there was, I mean, I don't know that, I think you'd have to prove some kind of a, you know, more than one occasion of that. It wasn't just a one-off or something that they didn't catch, but if you could prove that a business was constantly failing to follow the requirements, I think it would be within, and we have some provisions in the existing cannabis ordinance that talk about revocation of permits and stuff for failing to follow the rules. Yeah, I think that would certainly be something that is possible.
Okay, and I wish the state never passed this law. I just think it's not smart. But can I make a motion to make an amendment to something on here? Am I able to do that, Parker?
Yes.
I make a motion for section 27151, we remove some of the verbiage for section B. The first line I'd like to remove is the above notwithstanding, and then the word no.
Counselor, that is already removed. That's why it's struck through.
Oh, okay. All right, sorry. Then I would also like to include, after the third line, recreational sales, remove and on-site consumption.
B.
And,
You see, you're in a different, you're
no,
not
I'm
in,
not in the red line. Sorry, I'm in the original version. Okay.
okay, if you look up, and not in the red line, but if you look up on 151, if I'm correct, on item B, is that where you were,
Okay,
151?
on section 27151, section B.
Section B, so that's on the top of, well, these pages aren't numbered, but it's on line 4, on, right after we start on 151, on section 6, 27151, right after that.
So on
Then
line 6.
Top of the next page, and B starts on line 4, and she's talking about line 6.
Removing the underlined and on-site consumption,
Okay,
and then removing the verbiage on-site consumption permit if applicable.
and let's see, what line is that on? So just
8 to 9.
on line 8 and 9. Okay, does everybody understand that where that is? That's on-site consumption on line 6. You would strike that, is her motion. And then on line 8, from the on-site, on the end of last two words on line 8, and the 4 words on line 9, where it's on-site consumption permit,
If
if
applicable.
applicable, okay? So those are the 6 words she would like to delete. And that would, it's my understanding when I look at that, that would probably eliminate on-site consumption.
For pre-existing uses.
Or okay.
Right, not across the board. This is relating to non-conforming uses and the question of whether or not those non-conforming uses could get an on-site consumption permit without first having to go back and getting a zoning change. That's the question in this section.
Okay. No, I'm sorry, did we have a second for that motion? We have Council Lady Halverson has moved it.
I will second that motion to remove.
Okay, we have Councilman Perry will second the motion to remove that. Okay, now, so we're on that order of business discussion. Are there questions from Councilman Perry?
Thank you, Mr. Mayor. I would just like to say, no, I appreciate that, and I think that is definitely a move that we need to make for no consumption, and I'd like just sort of some clarification, either from Parker, Mr. Mavers, or someone. Consumption is consumption is consumption is the way I am assuming, and that would be, this isn't Baskin Robbins with the little plastic spoons to test the gummy bears or the brownies, or is that part of consumption, or is that taken out of consumption?
I don't know that I've seen that exact hypothetical, but I would assume that consumption is consumption is consumption. Yeah, you can't.
I don't get to go to my pharmacist and try my pills before I buy them and I go home.
I would assume that if there's on-site sampling of the materials, that would require a consumption permit.
Okay, thank you. And just for the record, I agree with the motion. I'm going to support that motion. When you look at the state, what the state passed in 26-2C-12 under the local control, one of the things that it does give us authority to do is this is a local jurisdiction may, and the word may means you may or you may not. You get to control that as the local jurisdiction. We may allow for smoking, vaporizing, and ingesting of cannabis products within an indoor or outdoor cannabis consumption area, and then it gives all the ifs. The way that I understand law here, and from speaking with you, that also means that we can also say we may not, that we can say across the board in Roswell, we don't want consumption in these establishments at all. And if you're going to take it home, the state has given you that authority to be able to go to your friends, whatever, but in an establishment, we have that jurisdiction and the authority to say no, not tonight. I understand that, but later. Is that true?
Counselor, yes. So, caveat, this is brand new legislation. There's not case law that I'm aware of that interprets what any of this means. But as I read it, if it says a local jurisdiction may allow for something, the inverse of that must also be true, that they may prohibit it, right? Otherwise, it's an irrelevant statement. So I would agree with that. Now that, just to be clear, and I think you touched on this, in order to prohibit it jurisdiction-wide would require an additional amendment, because this section only applies to whether pre-existing non-conforming uses could apply for this, not other new businesses that got their zone changed and all that would still be able to apply for this.
And I would think that it would not be appropriate to be trying to pull a bunch more into here. We need to stay with what we have on the table tonight. Okay, I'm sorry. I was asked for a clarification. I'm saying I support Councilor Halverson's to remove from this section. I think that looking at it across the board for our entire eliminating consumption completely, that's probably a time for another meeting to go through that through the legal committee and bring that back to us for that. That's what I would think. Am I correct?
Yes.
Thank you. Okay, Mr.
Next.
Mayor, I'm sorry. Can it be cut now? Can we just go ahead and make the amendment saying that we would like within the, but it wouldn't fit underneath this current portion of, it would take Mr. Mavers or you telling us where that is within, because we are dealing with the ordinance, so anything within the ordinance, I would think at this point, could be dealt with.
Yes, you are authorizing to advertise for a public hearing, so if you want to make additional changes, you can direct us. So if you wanted to, you could make an amendment to strike all on-site consumption out of Chapter 27, if that's the motion you would like to make. And then when we brought it back for the public hearing, we would have all of that ready for you in the version that we would bring to you at that public hearing.
Do I need to amend my motion to include that then, or?
Well, you can have okay, so we're getting into some procedure here. So you can have an amendment, and then you can have an amendment of the amendment, and that's as many amendments as you can stack.
So, Mr. Mayor, I will make an amendment to the amendment to strike any allowances for the smoking, vaporizing, and ingestion of cannabis products within an indoor-outdoor cannabis consumption area. So cannabis consumption area is completely from city code.
Second.
Okay, so, yeah. Excuse me, is this on this particular subject we have?
On his motion.
Okay, so we have Perry's on there now, and we also have Councilors Halverson and Hildebrand on talking on this, this subject.
Don't we have to vote?
And so we had a motion made by Council Lady Halverson and a second by Councilman Perry. And so that's where we were with the first motion. And now Councilman Perry wants to make another motion of the top of that.
Yes, Mr. Mayor, the motion is to amend the current motion that is on the table to amend, which would be to strike cannabis consumption areas from the code completely, from the ability to have them completely.
Second.
You have a motion. Okay. Might I ask Council Lady Halverson, do you have any objections to the amended motion?
No objections.
No objection. Okay, so now we're back on the motion then, as it would read now, would be to strike the consumption, on-site consumption from this amendment, or from this proposed bill that we have. We would direct staff to go back and strike that. Is that the way I
So the
read it?
motion on the table right now, or the motion pending, is the amendment to the amendment, right? And so
That's
that
right.
is to strike all cannabis consumption from the city code. There will be no on-site consumption within the
On-site
city.
consumption.
So we'll have to vote backwards on that. We'll vote on the amendment to the amendment. If that's approved, then we'll vote on the amendment. And then if that's approved, we're back on the main motion, but amended as agreed.
So now I have next on the list is Council Lady Halverson. You were on to speak on this. Do you pass, or would you?
No, I was just going to cover what,
Okay. And Councilman Hildebrand.
Yeah, I just want to, excuse me, make sure that we're covering all of cannabis facilities now and in the future will be under this adopted,
Yes.
changed ordinance.
Yeah, we would end up coming back with, assuming that all these amendments passed, then we would end up coming back with a new document that basically, that was explicit and said cannabis consumption will not be prohibited in the city of Roswell, on-site consumption. Permits, yeah.
Because I know when you, liquor store, you can't go in there and buy a liquor and open it up and start drinking inside the store, so.
Sure, but but I mean, you can drink liquor at a restaurant, right, or at a bar. So I mean, this
Right,
would
but
be.
you can't buy the quantity. You can drink it by the drink, but it's just so this is buying the quantity and is following the same guidelines. That's all I'm saying. And so what I approve of this. So
Yes. Now I've been trying to keep this straight as I can, but I have on my list to speak. I have Councilman Orpresa. Do you care to speak on this particular, or back on the original bill? Councilman Orpresa. Then I.
Thank you, Mr. Mayor. I just want to make sure that I understand the amendments. if this amendment passes, there will be no consumption in city limits?
On-site consumption.
On-site consumption is on city limit regardless of zoning.
Right, so basically, no business that's a cannabis business would be eligible to apply for and obtain a permit for on-site consumption if this amendment were adopted.
So this would eliminate any lounge type facilities if somebody was willing to come in and open a lounge, at whatever zone it may be.
Yes, sir.
Okay, thank you.
Okay, now we have Councilman Foster.
Mine's on previous. Let's get through these and
Okay.
I'll.
Okay, then I have Councilman, oh, she's gone. Councilman Hennebander, you're out? Okay. Okay. So, okay. So now we're back on a motion for this. If yes, this is on the amendment to direct staff who does is to remove all on-site construction, on-site usage of the cannabis at the sales location. That is the motion. If the clerk could call the roll. Right? Or do you want to vote? It doesn't.
We can do this amendment as a voice vote.
Okay. Huh? Yeah, you weren't on the button? Well, everybody else's worked, just yours. I bet they turned it off. Oh, excuse me. If we could, Councilman Corn, if you would, before we go to the vote.
Mayor, I was doing a quick research here, and I apologize, but I think Mr. Parker and I maybe can have a little discussion here real quick. Under state law, go ahead and pull it up, 26(2)C-26. And it talks about limits for personal use and penalties. And it says under this section number 1, A1, allow a person to smoke cannabis products in a public place, I can't even read, public place except in a cannabis consumption area, or restrict the ability of a person to prohibit conduct otherwise allowed in the Cannabis Regulation Act, the person's privately owned property. B, it says, a person who violates paragraph 1 of this section shall be subject to a civil penalty of $50. I didn't write this, I'm just reading it.
Could you give me that section again, so I can pull it up here?
26-2C-6 talks about limits on personal use penalties.
26 or 6?
Yeah, state 26-2-6.
Yes.
And then it further goes on to says this is, as used in this section, smoke means to inhale, exhale, burn, carry any lighted or heated device or pipe, any lighted or heated cannabis products intended for inhalation, whether natural or synthetic, in any manner or any form. Doesn't say anything about eating as far as the consumption question.
Well,
see.
here, this is the definition of
Is there another section of state law that I'm missing?
Well, the Cannabis Regulation Act is pretty big, so I don't know what specifically, but this one says, oh, here, let me see if there's a definition of consumption somewhere.
I think I've got the whole thing here. I can't see any place else where there's any restrictions.
If your question is there a definition of consumption, I don't see one right off the bat.
Okay. Well, this is the only thing I see on any restrictions in the public, period. So if we want to restrict consumption on the premises, then we can restrict consumption on the premises as in manner, correct?
Yeah, yes.
I don't know. It looks like to me that that falls under the purview of state law, and I'm just pointing out for everybody's consideration that state law sort of addresses it. To be consumption would be smoking, but that's just food for fodder, Mr. Mayor. That's all I have.
Oh, thank you. Is there any other councilman that wants to say anything on this right now before we vote?
Just my quick question. So do we need to address,
Councilman Moore.
I'm sorry,
Yes,
Councilman
go ahead.
Mayor. Do we need to address consumption then? Do we need to address that definition in this part or no?
No, I don't.
I mean, because if he said the state says something different, it doesn't address, so when we address our, do we have to say any consumption? Do we have to be specific when we say
Here's what,
consumption?
okay. A local jurisdiction may allow for the smoking, vaporizing, and ingesting of cannabis products within an indoor or outdoor cannabis consumption area. So the inverse of that is we can prohibit smoking, vaporizing, and ingesting of cannabis products within those areas, right? If we may do it, then we don't have to do it, right? We can prohibit it.
Okay, thank you. If there are no other, Councilman Perry.
Just for clarification, as I pulled up 26-2C26, the limits of personal use and penalties, Section 26, it addresses, if you read an A, nothing in Section 25. So it actually is dealing with Section 25, which is actually talking about the personal use of cannabis. So it's not dealing with the on-site consumption areas, which is what we're dealing with in this amendment.
As I'm reading this, what it's saying is that the Cannabis Regulation Act does not make it illegal to smoke or ingest cannabis in a consumption area if there is one. But if there's not one, it doesn't come up.
Exactly, and I think that's why Section 25 is given for the personal use of cannabis, to outline their rights, their abilities to do so, but it's not directing, because we've also got, we've got the Free Smoke Act, all the other stuff that they have to go with as well.
Thank you, Councilman. We'll, if you decide to give up your collar for a law degree, well, let us know. We'll work on that. Thank you. So, all right, seeing no further debate on this motion, the clerk will call the roll. You don't want to do it by all in favor? All those in favor signify by saying aye.
Aye.
Opposed? Aye. We have one negative. By a vote of 9 in the affirmative and 1 in the negative, Councilman Orepresso voted no. Okay, we're back on the original motion.
We got her amendment first.
Okay.
Just to be clear, we're on the original amendment, not on the main motion. We're on the original amendment, not on the main motion yet, right? We got to go backwards in steps. There was a main motion, motion to amend.
So we're back.
Motion to amend the amendment. Now we've done the amendment to the amendment. Now we're back on the motion to amend it. The idea being we have changed what the amendment is, but we still haven't adopted the actual amendment yet.
Yeah, so we're back on discussion of the original amendment
Correct. As amended.
as amended. So, is there any? I have on discussion back on the original amendment. I have Councilman Foster.
Still on the original motion, so
That's back where we are.
no, we're on the amendment.
Yeah.
Oh, okay. Okay, so we're back. Oh, I'm sorry. So we're back on the amendment. You're never supposed to amend an amendment.
You can stack.
Okay,
you can
so-
stack one amendment of an amendment. That's the limit.
Okay, so we're back on the original amendment. And now we have, you're not on this one, you're on the big bill. Okay. Hey, Councilman Perry, are you on this or on the amendment?
The amendment, so what we have is Counselor Halverson made an amendment. I amended that amendment. We approved the amendment of that amendment. Now we need to, the amendment is on the table, as was approved. So pretty much we're voting again to approve what was just approved through her.
I know that it feels like you're having to do the same thing twice, but just think of, so in the first time you were deciding whether to change what the amendment would be, and
Correct.
now you're deciding, and you said yes, and now you're deciding to actually adopt that amendment that you've changed, right?
Yeah, so we're now voting, is there any other discussion on the amended amendment? All right, seeing none, all those in favor signify by saying aye.
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 Opposed?
Aye.
So we have 9-1 against Councilman Opresa voting no on the amendment. So now we're back on the original motion. I have Councilman Foster on the original motion.
Thank you, Mayor. Thank you, Mayor. I'd like to call Mr. Mavers up real quick. My question goes back to section 27.5, and I want to know what fees are we talking about we would be changing that we would need to notify the cannabis board?
Give me just a second here to find 2705. The fees that we're looking at, what would happen with respect to the fees that we would normally be collecting. Okay. For all new projects coming in, we have an entirely new set of fee schedules for conditional use permits, zone changes, and other things. We collect a number of different fees so that we can process these applications.
And I hate to interrupt you, but my question is there going to be ongoing fees that we're charging existing cannabis retail establishments?
The only the answer to that question is there is no ongoing fees associated with it except their annual business license.
I got to disagree with you there, Kevin. There's the regulatory permit only lasts for a certain amount of time.
The regulatory permit, yes, is also an annual fee. Okay.
So there's
It's our operational permit. We changed it from regulatory permit to operational permit.
So there's a yearly operational fee, okay, yes. But all other is for newly cannabis organizations.
Yeah, there's again the one-time fee for conditional use permits, zone changes, variances, all the other things. All of those are one-time fees, provided that they continue to operate in good faith. Only the operational permit and their city business license would be an annual renewal.
Okay, so that comes back to the point where those are the only two reasons why we should send them a letter. We shouldn't be having to send them a letter every time we're wanting to change a zoning fee or something else, because they're existing businesses, and the logic of having to and if we're going to do it for them for a business license fee, then that would almost mean that we need to send out a license to every business in town that has a business fee for us.
Actually, I think the $35 business license is regulated by the state, is it not? That is the maximum we're allowed to charge. So that actually comes down from the state. We just, okay.
And so then the operational one would be the only reason why we would need to send them a letter, because otherwise they're already in operation. We wouldn't be changing their fees on them.
Well, I'll give you an example. Like what the gentleman earlier was talking about. Well, he's got a vice license, so he's got the ability from the state to do all of these things. But right now he's in, for example, and he's got his CCAN, right? Now he's like, well, I've got this ability to do industrial, so I need a new site in an industrial area in order to expand and fully use my vice license. So he's going to need to open a new spot and get all the zoning done. So I agree with what you're saying. I hear you 100%, but I also think that there are circumstances in which existing businesses would be interested in what the future regulatory and zone change and all the different permits would be.
But as I understand the way we operate, it would first go to a committee, correct? And then it would be heard by the city council, all of which are advertised, all of which we put it out on our website, we put it out on the city paper. It just gets to that point where it's not our job to educate businesses. It's their job to follow and understand. You know, I read the legal paper, the legals in the paper every day. just to find out who's going out to bid for what. It's their job to do their own education. It's not our job to educate. And so I see that this is unnecessary. And then the next problem is, how do we know we're going to hit everybody that wants a letter? So do they have a legal objection to, we didn't get a letter, so you can't pass
As
this
drafted,
ordinance
it's
change?
only for permitted establishments already existing. So it's not everybody who's interested, it's for existing licensed businesses within the city would get the notice.
But are we going to send it registered mail so that we have a,
I think I said regular mail.
so then all they have to do is come back and say, we didn't get it, and we can't pass I mean, it gets to that point. Why are we tying our hands to the point? It doesn't make sense to me. So I'll wait till we hear more, but I do think that eventually I would put a motion on or would be happy to second it to get rid of that portion, but I yield. I did have one more question for Mr. Mavers. Okay, under this ordinance, current medical facilities, do any of them fall into the 300-foot zone of areas that we would not have normally allowed a company to come, or a regular cannabis organization to come in and open?
Out of the current operating and the ones that have applied, this is the other thing that I think I made clear the last time I was up here. We have right now 7 cannabis applications working their way through the Planning Commission. The first 2 will show up. Out of the applications that we've received, 5 of the 7 include variance requests because they do not meet our standard setback requirements or separation distance requirements.
And being near, and what are the exceptions? Are they near schools?
The first 2 that are coming through on tomorrow, actually. The first one is only 22 feet away from a residential zone. And the second one is about 100 feet away from a residential zone, but is also less than 300 feet away from a daycare center.
All right, thank you. I yield.
Thank you. We have Councilman Perry next. And that's the final one I have on the list now.
Thank you, Mr. Mayor. And Mr. Mavers, don't go away. You and Mr. Patterson staying nearby. Let me start my questions by asking, because I want to make sure I've got my head wrapped around why we are here today versus continuing with what we have in place right now. Can you walk me through the current process on the books right now? Someone has a vice. Tell me, because that's what we're here for. We're not here about the new shops. We're talking about those existing. Tell me what the proper process is that council put into place to go through, if you could.
Okay. There are multiple different processes, but they're set up depending on whether or not we have a brand new facility coming in.
Now I'm speaking directly right now of those that are medical, that are currently, they're in a facility, their doors are open, they're selling. What is the process for them? Because that's really, from my understanding, what we're here today to address.
Okay. The current process is they would come to our office, they would pick up an application to do a zone change from their existing zone. All of the existing medical cannabis facilities are located in the C2 zone, so they're eligible for a zone change to our CCAN, our floating zone. Okay. One of the reasons we decided to go with a floating zone as opposed to just establishing areas within the city that would be allowable for cannabis is we did not want to be in a situation of picking winners and losers. We've seen this happen in a number of different cities where a city decides this area is where we're going to put cannabis, and there's a mad rush to purchase property in that area. Property values go up dramatically, and you locked into having one cannabis zone. By having the floating zone, we allow the developer, to decide where they want to be located, provided they're in an appropriate commercial or industrial zone. So the first step is to apply for the CCAN zoning designation. Second step is to apply for a conditional use permit. This allows us to review the application with the proposed end user, and determine what, if any, conditions of approval need to be established upon there. Pursuant to the state guidelines, of course, we're allowed to establish time, place, and manner. We also, though, have to be concerned about public health, safety, and welfare at the same time. We have one existing facility that has come in and requested a zone change and a conditional use permit. They are located within a medical office complex. We have another one that's located within a few hundred feet of a existing daycare center. We have others that have adjacent to residential areas. We look at all of these, and then we can adjust the conditions of approval for time, place, and manner. Something as simple as hours of operation. We're allowed to set hours of operation based upon neighborhood uses and those immediate things. The cannabis facility that's coming in, or that's requesting an upgrade to allow for the inclusion of recreational cannabis, is in an existing medical office complex. They are open, most of the people in that medical office complex are open from 8 a.m. to 5 p.m., Monday through Friday. We have every right, pursuant to state law, to establish that they can be open 8 a.m. to 5 p.m. Monday through Friday, based upon those surrounding land uses and those existing land uses. Things like that fall under the conditional use permit clause. If the sites do not meet all of our current requirements for siting, in other words, we have separation distance issues, or we have incompatible uses in the area, then we're asking them also to file a variance request. We allow them to file the variance request. That way they can come in and make the case before the Planning Commission and the City Council that they have the ability to apply specific mitigation measures that will reduce any risk or any further damage to those incompatible uses that are in the area. All three of those items are processed simultaneously in one large package. Okay? So when you go before the Planning Commission, you will go with your conditional use permit, your zone change, and your variance if it's required. It'll be reviewed by the Planning Commission. The Planning Commission will then make a recommendation to the City Council. The City Council holds final authority on all cannabis projects. The recommendation, of course, coming from the Planning Commission can either be for approval or denial, but it is up to the City Council then to make the final determination on all of these applications.
So with that, just a quick recap. They come in, they make their application for zone change, come in, make their application for the CUP, come make their application in for variance request. Those go before P&Z. Motion comes out of P&Z. Regardless of the motion for P&Z, it's going to end up at full council for a final determination. And in all reality, that could, on a regular basis, could be taken care of, and how much time theoretically could someone, because I think that the concerns that I'm hearing is the necessity to fast track, and that's what I'm just having a concern of understanding. I'm hearing two things when I get feedback. One is that I hear from one or two people that have communicated with me that we don't want to break law, we don't want to be sued. Well, I think we all know that regardless of what we do, we always run the risk of being sued, regardless of what we do. As I read 26-2C-12, and as I speak to our officials, to those who in these departments who understand these, it says a local jurisdiction shall not, and then number 2 is really what we're dealing with on a concern, completely prohibit the operation of a licensee. I didn't hear anything within the current guidelines or processes that we are completely prohibiting the operation of a licensee. Now, I understand that some could have been open on April 1 and they're not, but there again, there was a process that could have been gone through. And what was January until April 1 enough time for somebody to have walked through that process?
One of the things that we've been hearing, and I'll answer your question directly in just one second, is that we need to treat our cannabis businesses like any other business. Okay? So we looked at the process for a conditional use permit. So what I'm going to give you right now is the timeline for processing a conditional use permit, all conditional use permits, not just cannabis, but anyone who would walk through the door today that wants a conditional use permit and a zone change will be told that if they have their application full and complete by the 15th of the month, any given month, okay, they will go on the following month's Planning Commission agenda. The reason it takes about 6 weeks of time, though, is because 1 week before the Planning Commission, we have to have our packets done and sent out. 2 weeks before the Planning Commission meeting, advertising has to take place. So all of our thing. It takes almost 3 weeks, though, to get the information sent out to the newspaper so the newspaper can put the ad in, and at the same time we do that, we also have to send out certified mailing to all the surrounding residents. There was a question a few minutes ago about whether or not we send things out certified mail or regular mail, and are we setting ourselves up for problems? The answer to that question is yes. Anytime we send out mail, and it doesn't matter if it's certified, we almost always end up with someone in the audience who will say, we weren't notified. We literally bring the little green cards with us to every Planning and Zoning Commission meeting so that we can show that it was sent and brought back. Someone will always complain. So we have to back up 3 weeks. So if the Planning Commission meeting is being held on the 4th Tuesday of every month, by the 1st Friday of every month, we have to have everything done. We have to have our staff reports complete, all the advertising complete, all the mailing ready to go out. And then it's a matter of advertising periods and getting feedback from anyone who would complain. Prior to that, because of the complexity of these applications, it takes staff 2 to 3 weeks, and the number we're getting, it takes staff 2 to 3 weeks to pull everything together, to write the staff report and everything else. So realistically, if someone were to walk through the door with a fully complete application, and yet we have yet to receive a fully complete application. We always have something that's missing, something we have to go back, something we have to get clarification on. But if somebody came in with a full and complete application, it would take approximately 6 weeks to get to the Planning and Zoning Commission meeting. Then once we go to the Planning and Zoning Commission, regardless of whether they're recommending denial, it'll go 2 weeks and 2 days later to the City Council. So total time, approximately 8 weeks to go from application to final review and approval, review and determination by the City Council.
Thank you. And so a couple of questions here, and I do have some amendments, Mr. Mayor. I think that the respectful way for me to do this is not to try to cram everything I have into one, because there may be, that would bring a lot of confusion. So if you can give me an opportunity to ask some questions and look at these. I see that it was added into here, the language on, I'm looking in the packet, because that's what I have, and that's what I've been looking at the whole time, which would be on page number 6 of the packet, section 27-5 fees. On line 27, that it was added, the verbiage, fee resolutions adopted pursuant to this section shall be posted promptly on the Community Development Department section of the city website. Whenever the city processes to amend a fee resolution adopted pursuant to this section, the city shall, and it talks about the 2 weeks. After hearing the arguments for that was brought forth as to why that is from some counselors, I recognize that it's not a bad thing that we get it on the website as quickly as possible. I think that's appropriate. I think that I agree with Councilor Foster very much so that when we get into the process of having to deal with the mail and getting all this information out to folks, that this is we're going to miss someone. We're going to, and plus that's the taxpayers' time and energy of our staff going into all of that and researching all that and making sure we have our P's and Q's. So my first amendment would be that we would strike on line 20. Starting on line number 28 with the word whenever through line 32, the period, which would strike as reads, whenever the city of... Yes, sir. I have to use this. That red line is confusing to me. I'm using what's currently here. And here's the better way. If you're using the red line on your very first page of section 27-5, fees. Give everybody an opportunity. Would be, I pulled up y'all's red line copy. It'd be on page number 1, and I am looking at line number 28. My motion to amend would be to strike, whenever the city proposes to amend a fee resolution adopted pursuant to this section, comma, the city shall cause notice to be issued via regular mail to the business addresses of all existing establishments permitted under this chapter at least 2 weeks in advance of the public meeting at which such amendment shall be considered by the governing body, period.
Second.
Okay, we have a motion by Mr. Perry and a second by Councilman Foster to strike on line 28 from whenever to the remainder of up down through line 32. I think I got that correct?
Yes, Mr. Mayor.
Okay, we have a motion and a second, so now we have discussion on the amendment, or is there anything you'd like to say about it?
No, I'm
Okay.
perfectly happy
Everybody
with
understands the amendment, and we have questions. I have Councilman Orpressa. Not on the amendment, okay. Any other questions on the amendment?
We get one more time on the amendment.
Absolutely.
It's
Councilor Corn, the amendment would be on your red line copy on the first page, line number 28, beginning with the word whenever, to follow whenever the city proposes to amend a fee resolution adopted pursuant to this section, the city shall cause notice to be issued via regular mail to the business addresses to all existing establishments permitted under this chapter at least 2 weeks in advance of the public meeting at which such amendment shall be considered by the governing body, period. That to me would be just one more way to not to, as people are saying, treat this industry differently, if you would say. We don't do this for beauticians or tattoo parlors when we make these kind of changes. But I do agree with whatever counselor brought up and desired to have the put on the Community Development Department section of the city website. I think that's appropriate, absolutely.
okay, so the motion we have before us now is to strike on line 28 through 32, beginning with words whenever the city, down through the end of that, through the end of line 32. Any further discussion? All those in favor signify by saying aye.
Aye.
Opposed?
Aye.
Aye. So, oh, I don't get to vote, never mind. Just get one. 9-1, by a vote of 9-1, this amendment has been adopted.
Mr. Mayor, on, let me pull up y'all's page here. These are not marked with page numbers. Maybe a good thing if everybody was to go through and just maybe mark their pages.
Yes, there's 9 pages, I believe.
My-
Eight pages.
My next question is on page number 5 of the red line. I believe it's page 5 unless I've grabbed 2 papers at one time.
It's the one without a red line on it.
Yes, sir. That thank you. On line number 9, under number 2 of paragraph A says prior to initiating operations and as a continuing requirement to operate a retail cannabis establishment or industrial cannabis establishment, the legal representative of the persons or entity intending to operate and or lease a facility for this development of a proposed cannabis establishment shall obtain and pay fees associated with. It talks about an operational permit. And number 2, it says, except in cases of non-conforming uses, a CUP or a conditional use permit from the city as required by this chapter. I guess my question is, why would we not desire to see a CUP with non-conforming versus those that will be coming in the future as we look back, again, to state law saying that local jurisdictions shall not completely prohibit the operation of a licensee, yet we may adopt time, place, and manner rules that do not conflict with the act. So that would be my question. I don't see that this is shutting anyone out from their ability to do business. It's just a process that the state has allowed the city to go through to make their determinations. So my question is why would we exempt non-conforming uses in this section? And I don't know who wants to try to answer that.
So I guess the only answer I can give you there is that that was what was requested that we do was get rid of both the zone change and the CUP and have the businesses that are non-conforming just go straight to the regulatory permit. That was the ask, and so that's how we did it. And it's not the only place in here that you'll see that. So that part is really just, like I said in my presentation, cleaning up the other side of that, because where it actually is in the section on non-conforming uses that it says they shall not be subject to a zone change or a conditional use permit. And I will say I think that those do go together in the sense that the conditional use permit is typically associated with the zone change. That's the conditional use goes with it, right? You change the zone, and as part of that, you get a conditional use permit generally, although Kevin could probably tell you that I'm wrong. He knows more about it than I do.
So with that, that leads us now over, so I'll go ahead and pull over. I'll move past the timing for now and move over to page number 7, which does deal with section 27-151, the authority to continue, and on page 6 as well, because it bleeds through there, with the striking of rules and regulations, and then just go straight to the operational requirements of section 27-102. So as I read this in B now, it's going to say, upon the issuance of an appropriate state license, and let me start there. What does the word appropriate mean here?
So let's say that they are applying for a CCAN and they have gotten a permit for manufacturing. That's not an appropriate state license because they can't do that there. So it would have to be a state license that applies to the type of use that they want to do in the place that they're at.
So in that case, it would be an ICAN versus a CCAN.
That's one example.
Okay. It goes on, upon the issuance of an appropriate state license, a previously permitted nonconforming medical dispensary shall be permitted to engage in retail recreational sales and on, well, we've eliminated that, without the requirements to obtain a zone change or CUP, but such establishment shall obtain a city operational permit on-site, forget about that, and all of the applicable permits hereunder and pay all fees. So my question is this: what regulatory authority are we giving away by eliminating these areas? What will are there areas where they will be able to do something that otherwise we could have under the state's guidelines of time, place, and manner that we could have regulated that we're giving up by removing that language?
I would defer to Kevin. He's much more into that stuff than I am.
Mr. Mavers, if you'll give me the 30-second answer on that one.
Councilor Perry, if you just repeat your question one more time to make
My
sure
question
I understand.
is, with the removal of the language in that section, number 1 of removing the subject to the rules and regulations, which just leaves them with an operational license, and B, with removing the regulatory, and it just goes to the operational, removing the CUPs and everything. So now we're just giving them the operational license. What regulatory authority that the state has given us? Because the state does not say in A of their local control, local jurisdictions may adopt time, place, and manner of rules unless they are a continuing non-conforming. It doesn't say that. I think time, place, and manner can be established for all. It just says that we cannot completely prohibit the operations of a current, of this licensee. We can't do that. So my question is, what regulatory authority are we taking away from ourselves by having this verbiage here in B and A and B?
When we're dealing with time, place, and manner rules in particular, by giving away the requirement for a conditional use permit, by giving away the requirement for the zone change, okay, we are severely limiting ourselves in establishing safety protocols. We're limiting our ability to establish parking requirements. We're limiting ourselves even under state zoning regulations and development regulations. The change from just a medical dispensary to a recreational dispensary constitutes a material change in operation. Okay? There are different ways that we look at how that's happened, not the least of which is whether or not that facility is appropriate at that location. As I was saying before, we have some of these that do not meet our current zoning requirements that we're automatically going to allow to significantly upgrade their facility, to significantly increase the level and intensity of use. And by automatically just waiving the requirements for the conditional use permit and the zone change, we give away our ability then to regulate our times, days of operation. They will continue as a non-conforming use under whatever hours of operation they have right now, if they even have any hours set based upon our previous permits. Okay? They will continue to operate in the manner that but they will just add recreational cannabis to it. Again, it's a material change in the operation, a significant change in of course, the entire industry is anticipating it's going to be a significant change in the level of intensity of use. Under normal circumstances, that would make them a non-conforming use because they don't comply with our current rules and regulations, and we would have the opportunity to set development standards and regulations that are consistent with that increase in level of intensity, not the least of which is our ability to determine whether or not that increase in intensity of use poses an increased risk to public health and safety.
Kevin, can I make one minor comment there? They would, under this amendment, be subject to the operating times that are in the ordinance, notwithstanding their non-conforming uses.
Well, that's one of the things I think in the operating times that are in here, that would establish operating times citywide.
Yeah, but I'm
Those
just saying
may
they
or may
wouldn't
not be consistent with the local neighborhood uses or needs.
Right, I'm just saying that whatever they're operating now, if this were to go into effect, they would nonetheless have to follow that. They wouldn't just be able to say, well, we've been open till midnight until now, so we can stay open till midnight.
Correct.
Okay. So with that, Mr. Mayor, I desire to make an amendment in that because I always question the state has given us authority. And I don't understand why authority that the state's given us that we're wanting to say we choose not to exercise that authority. And now you may say, now I don't want to be say that sarcastically. It may be saying we choose not to exercise our authority in that manner. We're going to choose to exercise our authority in other manners. But we have this ability. This is not keeping these establishments. I can't force any establishment to come down and go through the processes that have been set forth for us to do that. I can't force anyone to do that, but the process has been there since January. So I don't understand at this point why we would want to dismiss any of those regulatory authorities. So the best way I know how to do this amendment, we'll see if it passes or fails, would be on page number 5, on line number 9, it would be to strike the new language of except in a case of non-conforming uses. And then page number 6, it would pretty much reverting what has been added. It would take away the striking of rules and regulations, and it would take out, it would strike operational requirements of Section 27-102 relating to retail sales, including operating times. And it would also strike the word "the" in that line on line 1. Then on line number 4, it would remove the striking of the above notwithstanding, comma, no, and it would strike upon the issuance of an appropriate state license, comma, a previously permitted. It would strike line 6 and on-site well, we've already stricken that. We would remove the striking of unless the dispensary complies with the requirements of this chapter, comma, including. It would strike out the word without. It would strike out the word or on 8, strike out, the best way to say this, it strikes out anything underlined, and anything that is stricken through would now be brought back into it.
Returns it to its original form. Counselor, if I understand what you're saying, if this amendment were adopted, I think if I got this right, the only remaining portion of this amendment that would still be standing would be the 2 sections setting citywide operational hours. I think that's right. Because, of course, if we return it back to how it was before, and same with the other one, there would be no reason to put them in here at all. We're not changing them.
Yes, sir. So in that amendment would be to just, these sections, which I was just speaking of, because I do see I'm confusing people, and I'm not trying to, I'm tired. It would just be to place those sections back as they were. I don't understand. I do not want to take away anyone's liberties that the state has given them to do anything that's legal. That's not what this is about. It's about us continuing to be able to exercise our abilities to regulate. And I don't see that there's a fast-track concern in that. I was really waiting to see what would be finally brought forth to us, and I don't see that what we have is so encumbersome that someone cannot operate. So that's the motion to amend.
I'll second it. I'll second his motion.
We have a motion on the floor by Councilman Perry, seconded by Council Lady Best, to make those changes. I'm sorry, I didn't get all of them down. But you.
I've got them.
Is there any further discussion on discussion? I have Councilman Orpresa. Are you here? No. And Councilman Moore?
I had kind of the same kind of concern, and because it was like, if it's paperwork, they had the same notice. That's the same thing. If it's paperwork, it's not an inconvenience if they're already established. Not like they're going to lose any money. They're already in the process. So what's the need of going back for this if they're already started the process? Because we're going through all this, they should have. Hopefully, they're not waiting for this to get done to start the process. And to me, a lack of, the saying is a lack of preparation on their part does not constitute an emergency on ours, because they did not start the process when the process was able to be started. So that does not constitute an emergency or us doing something illegal or us trying to, set them back or do something out of order or something illegal. He just read the law. What we're doing is not illegal. All the time that we put in this was not illegal. What we're trying to obtain, I'm not for this at all. So, but I'm trying to be fair and listen and do these type of things. So I'm trying to listen and go and understand it. But something that Mr. Mavis just said that really struck me, and I hadn't even thought of, is safety. We are giving away some of our safetiness of our kids and where these people are already, and I'm not okay with that. So I totally agree with putting this back the way it was, because it gives us this particular verse, not all the rest, not this particular one, takes away so many of the city's, I can't think of the word, regulatory, and I'm okay with changing the regulatory operational. I understand. I'm okay with that word. That was somewhere you took that out, but I'm okay with that. So why would we take off rules and regulations? They still have to abide by them. Why would we take that word out? So now they don't have any rules and no regulations. So don't take those. So you take those words out, like you're taking the city. It's more like you're tying the city's hands, is the way I see it. You're tying our hands for these seven businesses. You're tying the hands for, for these businesses. And I want them to make money. We know it's about, I'm a business major, so I understand about the business and the making money. But at this point, I just feel like if they had followed the guidelines, we wouldn't be here. We wouldn't have been, I'm not saying that they don't deserve to sell and do what they want to do, like I said, I totally disagree with it. But if they were, like they said something, I guess somebody made my saying earlier, if they were a beauty salon, and I decided to open a daycare, I still have to get the provisions, get the guidelines, and do for my daycare. I still have to be able to operate under both of them. So why don't they? Why don't, just because they already open, I'm already open as a salon, and I decided to put some babies in there, I still have to go by those guidelines. So I don't understand why come they're not just doing marijuana medical anymore. I understand the state said that they could still operate, and that's fine and that's fair. But if they can still operate, let them operate by our guidelines that we've already set forth. That makes sense. They're not losing anything. If they had started on day 1 in January, they would have been already selling, making their money. And then they're already open, and so it's not like they're losing anything right now. So I'm okay with that. And that safety word it should be ringing everybody's ears. The safety of our children, the safety of our city, we have to be careful. And I know that they have strictest guidelines for doing medical. I think the whole game is going to change when it goes to recreation. The whole game is going to change. They might think it's not, but the whole game is going to change when any and everybody can have access. And so I think if we can limit it just, to a little bit, all it is some paperwork. They still going to have to, according to this, they're still going to have to pay all the fines and fees. So it's just paperwork. And so I just don't, so I kind of agree with going back to that, because I want us to have some type of hold, be able to do something. And if we just take it all off, or we don't have any choice just because they've already been here, and I expect them to. I'm not saying for any of you guys that are open, I'm not saying that you're not going to do what you're supposed to do. I know you are, because you've got guidelines and everybody's watching. So I just think I'm okay with the changes that to change, turning it back. I mean, putting it kind of back the way it was, with notwithstanding, and get rid of that the changes that we just.
Thank you, Council Lady Moore. Is there any other discussion? Okay, would you read the amendment that you have for further discussion? You want it? Oh, excuse me. Councilman Hildebrand wants to discuss this.
I hear you, councilors, very loud and clear, but the instructions at last council meeting was to send this back to legal. And that's what we did. So what I'm hearing is we should have killed it last go-around instead of sending it to legal. Now we've gone through this whole process of going to legal so why did we send it back to legal?
Mayor, I can answer why my motion is that way. My understanding is that there was a desire to find a way for us to streamline. I'm all for streamlining better. I'm all for streamlining better, to make something better, to make something more productive. I didn't know what we would have. I wanted to give it an opportunity that if we could find a way to streamline better, we could. And this is not a knock at anyone. It's just I don't see through what we have proposed it may be a better streamline in the end, or a quicker process for someone to open, but I don't see that quicker process necessarily has become what's in the best interest of the people of Roswell. That's my concern. I didn't know what to expect. I'm not on the legal committee, and I apologize that that my concerns are coming now, but I needed to hear and see where we were going to go. That's why I sort of held back to the end, hoping that maybe there was some explanation as to how this was going to streamline and yet allow the city to continue to uphold their ability to regulate these things. And I'm just not, no one so far has been able to tell me that we're being able to do both, that we're being able to still retain our portion of what the state has in place for us, and yet to make this streamline go quicker. That's what I'm trying to understand. And if somebody has that answer for me, I'm more than glad to entertain to hear that, but I have not heard that yet in this meeting.
Thank you. Is there any further discussion? Okay, seeing none, so would you read the amendment back by page number or whatever, and so we can make sure everybody's following correctly?
We are returning subsection B there back to its original form. So that would read, the above notwithstanding, no non-conforming medical dispensary shall be permitted to engage in retail recreational sales.
That's on page 7. That's where you're,
Yes, sir. No, page 6. Page 6.
subsection B.
Yes, sir. Yes, sir. Page 6 of the red line version.
Okay. Okay, I've got that. Now, what line number?
Beginning on 4, we're going to return it to its original form. So it will read, the above notwithstanding, no non-conforming medical dispensary shall be permitted to engage in retail recreational sales unless the dispensary complies with the requirements of this chapter, including the requirements to obtain a zone change, CUP, and all other applicable permits hereunder, period.
All right, so that's page 7 on the red line, Bill. That's why it doesn't work.
Excuse me, for some reason it's showing page 6 on my computer, but I don't know why.
All right, page 7 on the, so you're gonna take on item B, you're gonna remove the line through.
No, put the line through back in. The strikeout, the above notwithstanding no, comes back. The underline, upon the issuance of an appropriate state license a previously permitted, is now gone. Non-conforming medical dispensary shall be permitted to engage in recreational retail sales. On-site consumption is struck unless the dispensary complies with all the requirements of this chapter, including is brought back in because that was struck out. The requirements of a zone change, CUP, and then strike, but such establishment shall obtain a city. And this is one question for you, Counselor. It said regulatory permit, but that is, we did change that to operational, so that would be one change that maybe we retain. That's just.
And I see that, so yes, that part of my motion would be to leave that change, because I do think that clarifies better.
Let's see, where was I? Oh, operational permit, then on-site consumption permit, if applicable, is struck, and all other applicable permits here under, and that's the end of it. The rest of that is no longer there. So all the underlines are taken out, and all the strike-throughs are put back in.
In item B, in item from 4 to 12.
With the exception of regulatory is still struck and operational still put back in.
Okay.
And Councilor Perry, was your intention to also change back subsection A to its original form? Right, okay, so
That's on page 5.
beginning at line 43, any previously permitted cannabis establishment and/or cannabis-related use, including medical dispensaries and retail cannabis establishments that existed lawfully prior to the effective date of this chapter, may continue to operate as that same use as it did prior to becoming non-conforming, subject to the rules, regulations. So we're bringing back that strikeout, and then we're getting rid of operational requirements of Section 102 relating to retail sales, including operating times, and restrictions listed below. So again, we're just putting.
You're on page 5, line.
It's section 151, authority to continue, beginning on line 43.
Line 43, Okay, so that's 40. Yeah, just, we need to get everybody, let's not do this again unless everybody gets on the same pages with numbers.
Yes, sir. And I apologize for not having page numbers on this. We turned this around really, really quickly between the two meetings, and that was my omission.
Okay, well, thank you. We're all making sausage. We gotta be all on the right, make sure we get the right sausage.
Yes, sir.
Okay, so is there any other further questions on the amendment?
Mayor, the other question I have, didn't you want to change line 9 on page 5? Except in case of nonconformity?
That was part of my motion, yes.
Yes, right.
So there are 3 places we're changing. Page 5, line 9, page 6, lines 40, on 151, lines 43, isn't that right? 43 through 46. Is that right? And then, on line 7, there are 1 and 2 on page 7. Any further discussions? Okay. Let's see, we should probably, we need to have a voice vote, or would you like, is it closed? All those in favor signify by saying aye.
Aye.
All those opposed? Aye. Okay, so let's have can we have a roll call vote, please? On the motion.
Counselor Arnold?
No.
Counselor Oropesa?
No.
Counselor Hildenbrand?
No.
Counselor Halverson?
No.
Counselor Sanchez?
Yeah.
Counselor Corn?
No.
Counselor Moore? Counselor Best?
Yes.
Counselor Foster?
Yes.
Counselor Perry?
Yes.
It's 5-5, Mayor.
What happens then?
You get to vote.
All right, first time, come on. I vote no.
Vote been recorded, Mr. Mayor.
Well, so as a vote of
Fi-
5 in the affirmative, 6 in the negative, the motion fails.
Correct.
So we're back on,
Mr. Mayor, my only last thing that I have, and I will, I'm tired, everyone's tired.
5 hours from our record.
With
Just
one
kinda-
item, with one item, Mr. Mayor. I think that part of the legal committee, some folks that had to leave early, we actually had representations. I don't know, I don't want to speak on behalf of them as being here representing the school system, but we did have principals and vice principals here. Counselor Foster may know of what schools they're with. I can't remember. Roswell High School. I know that there's a lot of concerns right now. There has been some major changes just since April 1 within the school systems and different things. I spoke about some of that last time, so I won't bring all that back up again. But there again, under what we are allowed to do per the state allowing us to deal with time, place, and manner. I recognize that the original determination of the council was going to be that this was on a case-by-case basis, determining where they were. There are places in town, our Main Street Roswell's usually shut down at a certain time of night. Other areas of town are open up later. You've got your medical. I had one person in a medical professional office that did contact me and said they've got major concerns. If they're open late at night, they're the only person within the entire area that is open that late at night. They're concerned that now they're going to have to add more security, potentially have a security person to be paid to drive through from time to time because of their concerns of their property. They did not have the concerns with the medicinal like they are going to have with the recreational in an area that was not designed for T-shirt stands or recreational gummy bears or anything like that. So there are concerns from those areas. But since from the last vote, there may be potentially a desire of the council to set standard hours. I went back and I looked, and I may be incorrect with this, but I found there to be 6 medical establishments right now. If there's more, I apologize, but I found 6 online. Looked at their hours of operation, and the vast majority of them are in the areas of 50 hours a week, 52 hours a week, 51 hours a week, 54 hours a week, 59. There is a 69 and a 74, but with the new hours that are listed here, this bumps everyone up into a 75-hour. It does give us that ability to regulate that. At the P&Z Commission, it's my understanding that the first applicant that went through, that the P&Z determined and that it was agreed upon the hours of Monday through Saturday, 9 to 6. Am I correct on that, Mr. Mavers? No, I think I do have that wrong. I got it right here. I'm sorry, I've got it correct right here. Monday through Thursday, 10 to 6, Friday through Saturday, 10 to 8, and Sunday from 12 to 5 were the hours that were discussed with that particular facility. They were going through the proper channels to get their permitting and licensing in place. It's my understanding that through testimony it was even said that there were no intents right now to be open on Sunday. They wanted to spend time with their family.
Actually, that information came from the ETZ meeting.
I'm sorry,
last
you're
week
correct.
from
Thank you.
the county. One of our currently licensed cannabis distributors here in Roswell is opening up a cannabis dispensary in the county, and those were the hours they requested. We wanted to figure if that's what the county was doing and that was what they were willing to accept, that was a good place to start here in Roswell as well.
So seeing that there is a desire that has come out of legal to have hours of operation, and I do recognize that it has been amended in legal from Friday and Saturday from 9 o'clock to 9 o'clock instead of to 10, I would like to make a motion that we see for the recreational use selling of Monday through Thursday 10 to 6, Friday through Saturday 10 to 8, and I'd like to see closed on Sunday if there's the support.
Counselor, can you give that to me one more time? I'm sorry.
The hours of Monday through Thursday 10 till 6, Friday through Saturday 10 till 8, and Sunday establishment closed.
Thank you. Thank you.
And if I may, Mr. Mayor, just to say this in argument for that, I recognize it's a different day, and I recognize that I can't bring, when I took that oath of office to be a city councilor, I can't bring every moral determination that I personally uphold for my family to a vote. I have to look at what is legal and what the restrictions are, what the abilities are within the state of New Mexico. The state has given us the authority of recognizing that each local area, each local municipality or county or whoever that other jurisdiction may be, there may be things for your city that in Taos that may not work here. There may be something that works in Albuquerque that doesn't work in Eagle River. There may be something, et cetera, all the way down through the line. I just think that that we have to be careful. Even without having the recreational open right now, we're already seeing significant changes on the street or in the schools, and I just want to try to keep that effect as close as possible. I think that this is more than reasonable with those hours that have been mentioned thus far. That gives them 8 hours a day, Monday through Thursday, So that's 24, and that gives them a total of 10 hours, 34, 44. That gives them that ability to be open. If those hours are not amenable, I would be more than willing to listen to see what else would, but I would like to at least see those Sundays restricted. I yield.
Okay, next on the agenda, we have, Councilman Represa, no? Okay, then we have Council Lady Moore.
I think he said what I was going to say about Sunday. That was the other time I didn't really care, but I'd kind of prefer, if we could limit to Sunday. And I guess because I am in a high school situation, my understanding of what's been going on and the situation that has changed so drastically scares me, and that's why I threw the word safety out so often. And that, of course, I'm still sad that we have given up the privilege of keeping some people safe. And so at least I still kind of like Mr. Maver's idea about where it was based on the area. Because like she said, if they're 95 and now they have to, but I guess they could still close at 5 though, huh? Even though, because they could still have their own hours. So they could still close at 5 if they were like in the medical. So they wouldn't have to necessarily stay open and have extra security because they could still close. But I understand it's all about the money. So that's my only situation. I was just okay with Sunday, but he said that, so I could have shut up.
Thank you. Any further discussions? Councilman Hildebrand.
Councilor Perry, do you mind repeating those hours of operation that they currently operate in? Thank you.
So repeat that one more time, I'm sorry.
The
hours that the current medical.
Well, there are several, but I'd be more than glad to give those to you. The ranges, absolutely. And I apologize, we have some out there, so if I get their times wrong, I apologize. I've got so many papers up here, give me a moment to find. I have, if the hours are correct online, we have one that is 10 to 7 Monday through Friday, 12 to 8 on Saturday, and closed on Sunday. By the way, out of the 6, we have 3 right now, as I see online, that are closed on Sunday. Oso, Bryant's, and Pecos Valley Productions. Now, they may be open on Sunday. No, they're closed on Sunday from what I can see. But the hours that I have right here, I have one at 51 hours a week, one at 59 hours a week, one that is at 69 a week, one at 52 hours a week, and one at 54 hours a week. And if I missed one, I apologize. Currently, by the hours that I just gave, would give them 62 hours a week, which is more than 1, 2, 3, at least 4 of the 6 that we have.
So,
What has been passed with P&Z for that one would be 10 till 6 Monday through Thursday. Current hours, I have a lot of 10 to 7s.
Monday through Thursday?
Monday through Friday.
Monday through Friday.
There is a 10 till 8 Monday through Saturday. There's a 9 till 8 Monday through Saturday as well.
So the latest they're open is 8?
Yes, sir. So far from what I can see. Be Monday through Thursday, 10 till 6. Friday and Saturday, 10 till 8. Sunday, closed. And that is going, Councilor Hildebrand, strictly off of what came out of the agreement that was made through P&Z. So we've already got someone who's, if passed permanently, is going to be operating at those hours.
Yeah, but that's just for one.
That is
That's
correct.
just one that's gone through P&Z, not all who've gone
That
through
would be
P&Z.
correct.
So, I wouldn't be opposed to a 10 to 7 and 10 to 8.
Say that again.
I would not be opposed if you were to look at it from where they're currently operating and telling
Okay.
them that you've got a recreational side that we're going to close you at 6, but your medical side can stay open till 7. And I don't know what our regulations and rules that we have, Mr. Patterson or Mr. Mavers, on the hours of medical as they currently sit. Does the city have regulations for those right now?
I believe that outside of this question of pre-existing uses, there's not really any distinction. I know there's not on the state side, and I don't believe, other than the non-conforming use issue, we don't distinguish between medicinal sales and other recreational sales elsewhere. If you've got recreational, then you're doing medicinal at the same time. That said, I mean, if you wanted to carve that up, it would be, I think you could do it that way, although it would be harder to
Right.
police. And
Hildebrand, out of the spirit of compromise, I see where you're coming from with that recognition of that magic number 7 already being done by many medical. So I would amend my amendment to make it Monday through Thursday, 10 till 7, Friday through Saturday, 10 till 8, Sunday closed, which would give an extra 4 hours a week of operation to now a total of, if I'm doing my math correctly, of 66 hours of operation, which is vastly more than the majority of those operating now. If the one that seconded, I don't know who gave me a second, if they would.
I'll go ahead and accept that also.
Okay. Is there any further discussion on that? So what we'd be voting on now would be 10 to 7, Monday to Thursday, 10 to 8 on Friday and Saturday, and no Sunday sales. Is that any further discussion? Okay, all those in favor of that amendment signify by saying aye.
Aye.
Opposed?
Aye.
So by a vote of 9 to 1, it passes, with Councilman Orpesa voting no.
Mayor, I yield.
Okay. So okay, so we have, yield, we're back on the original, your original motion.
Mayor, a little housekeeping.
Yes,
We've amended this thing, so I guess the motion was made by Perry, so he needs to change his withdraw. I guess legally, he'd withdraw that motion and make a motion to publish as amended.
I think that with the amendment going forth, now we are working on an amended motion.
Okay, so you had brought it, you made a motion, then you changed your motion, which the second agreed to, which is, I think,
Okay, I
permitted under
understand.
Robert's rules, then there was a vote, and so now we're on the main motion as amended.
as amended.
Thank you.
Is there any further discussion? Oh, excuse me. It's your turn now. You've been on here for a long time. Councilman Orpez.
Thank you, Mr. Mayor. I was wondering when you gonna get to me. You know, I think I'm hearing conflicting information. So I need to ask Mr. Mavers a question. How many, or have we received any applications for on-site lounge type of business, cannabis business?
As of today, the answer is no.
Okay. Have you had anybody call you in reference to information or that kind of stuff?
Yes.
So there's a possibility that there's some that are interested in opening a lounge.
Lounge, restaurant, whatever you want to call it. The opportunity for cannabis-infused products is as large as your imagination.
Okay. The concern that I have is we are limiting, if I understood it correctly, we are limiting anybody that is interested in opening a lounge in the city limits, regardless of whether it's an industrial zone or whatever zone it is. If I understood the information correctly, we will not be able to have any lounge type of cannabis on-site consumption. Is that correct?
The way the ordinance is written today, okay, there's multiple steps to gaining a permit for a lounge or an on-site cannabis facility. Okay? And one of the reasons we've separated on-site, added a second permit is, if I were just to draw a parallel between alcohol and cannabis. Okay? The existing facilities we have today, even if we add recreational, are going to be like your local Alsops. You can walk in, you can buy your cannabis, you pay, you leave, you go home, you consume, just like you do at Alsops. We go, we buy our beer, we buy our wine, whatever we want to do it, and then you go home and pay. When you start talking about on-site consumption, now that is a whole nother world. That's like going to a restaurant and a bar or something else. Even if you look at the state licensing requirements, state licensing has server permits for cannabis that have to be obtained. They have a number of different regulations that specify how the cannabis is handled, how it's delivered, how it is, and these regulations are changing all the time. So to automatically add in the ability to consume cannabis on site sets up a whole new regulatory paradigm that we are not prepared to deal with, and quite honestly, none of our existing cannabis facilities are prepared to deal with as well. None of the existing cannabis facilities we have room for on-site consumption and have it to be done in a proper way. The section of the ordinance, the state legislation that Parker was referring to earlier actually has a carve-out in it that allows for on-site consumption smoking, vaping, and things like that, which is a carve-out that's separate, that allows for an application, allows for the city, if we want to get away with not complying with the state or even our local Clean Air Act. We can set up completely separate rules. We don't have to comply with the state's Clean Air Act, but it's just for smoking, vaping, and other and consumption in that manner. Doesn't talk about any of the rest of the ways of consumption.
But the amendment that was made to this regulation or for reading, if I understood it correctly, and Mr. Parker can correct me if I'm wrong, but I understood that there will be no lounge type on-site consumption businesses of cannabis. Is that not true?
If adopted, this ordinance would prohibit all on-site consumption facilities in the city of Roswell, if adopted.
So we might as well tell anybody that is interested in opening a lounge or whatever, don't even bother coming in and making an application because you're not going to get it.
I believe, if I remember correctly, the discussion that was going on, I believe even our city attorney made a comment that I would have a different take on that particular section of the state legislation than he does right now. Because I believe, and I'll take a look over his shoulder a minute, if what's written is the way you describe, that may be a violation of state law.
And that's where I was going with it.
I'm sorry, I missed the first part of this question, so I'm kind of out of the loop on exactly what we're talking about. I was out of the room.
My understanding is when the amendment was made, it covered all on-site consumption facilities.
Yes, the amendment that was made was, and it was agreed, the amendment was adopted, would prohibit on-site consumption citywide. So there would be no point making an application. That would basically strike that entire section. That was the amendment.
And so if I understand the state regulation or rules, we cannot discriminate. We should treat everybody the same as if, regardless of what kind of business they're in.
I'm going to ask, Was that within the existing non-conforming use section?
No, everywhere. Totally prohibited. That was the amendment.
Again, I'm not the city attorney, but my interpretation of state law is pretty much the same as yours, Councilor Oropesa, and that would be, in fact, if we were to put that in there and not provide a path for some way for people to have on-site consumption, which is allowed under state legislation, that we would in fact be in violation of state law.
My understanding, again, is we can regulate where they are at, the location, the time, and those kind of things. But I don't think we can eliminate anybody from opening a business, just like we can't eliminate any other business, the SOB business, we can't eliminate those. And you know, and of course, this is new territory that we're in. And I hate to start off in the wrong foot by violating state regulation if indeed we are going to eliminate or prohibit anybody from being interested in opening a lounge, regardless of whether that lounge may be. And, you know, having to pay an enormous amount of money for the defense of this ordinance. Thank you, Mr. Mayor.
Thank you, Council Lady Moore.
Counselor Moore, can you turn on your mic, please?
Didn't you already say that we were not in violation, that you pulled up, and Counselor Perry also read it, that us being able to consume on site is not, that is one of the things that we can do?
Okay, let me start with my caveat again. There's no case law interpreting this statute.
May or may not.
I can't guarantee, there's no precedent that says this is absolutely what it means. Okay. But to the point of Councilor Perry, what it says is, a local jurisdiction may allow for the smoking, vaporizing, and ingestion of cannabis products within an indoor or outdoor cannabis consumption area. If we may do it, obviously, then we don't have to do it. So we may not do it. And that is the argument.
So therefore, then it wouldn't be illegal. At this point, from reading it the way you look, it would not be illegal, but anything can change, and we'd have to, either way it goes, there's a possibility of being able to be sued or whatever. That's going to come somewhere anyway, but no matter what we do. But according to what you just read, if you say we may, then we also may not, and we've already chose to may not.
Well, you haven't chosen it yet.
When we vote on this next one. Okay.
Right.
Council? No. Is there any further discussion? Okay, so let's see, we're back on the regular amended bill. Amended amendment, yes. So, no discussion? Okay. All those in favor signify by saying aye.
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 All those opposed?
Aye. With an explanation, please.
Okay, we have those opposed, I have Oropesa and Councilor Hildebrand, and anyone else? Council Perry. Okay, anybody else? Okay, to explain their vote, Councilman Oropesa.
Thank you, Mr. Mayor. You know, again, I want to emphasize my vote is not against the cannabis. My vote is more of protecting the city of Roswell than anything else, because my understanding, again, is that we should not be able to prohibit anybody from coming in and making applications for on-site use as a lounge. And so I believe that we should be able to allow people to come in, but we do have the ability to determine the locations and times and those kind of things that we can control. But I don't think that we can determine what business can come in and what business cannot come in, especially when we're on a new type of businesses with cannabis. And so I don't believe that we should prohibit anybody from being able to come in and invest in the community. And of course, without them as well, we're going to be losing revenue for the community. Thank you.
Thank you, Councilor Pressa. Next, I have Councilor Hildebrand. Oh, excuse me, Perry. You don't want to explain?
No. My explanation is just that I do think if we have anything that's overcumbersome, I'm ready to see those changes made. I just at this time do not see that that giving up, in my opinion, those things which the state has given us the opportunity to do is necessarily in the best interest of the constituents that I serve. So that's the reason I voted as I did.
Thank you, Councilor Hildebrand.
Yes, thank you, Mr. Mayor. I happen to understand that the state did an injustice of dumping, they ran through these regulations rather quick and forced this liability back on municipalities, which is sad by the state legislatures and the executive branch up there, which has forced us to make rules and regulations which may be in conflict with state law. So I agree with Councilor Opressa that one, we're being restricted whether we like it or not. We don't need to be in violation of state law, and things are not best settled in the courtroom. That's the most expensive and unfavorable decision you're ever going to get in your life. So, and the other thing, Mr. Patterson, when I was understanding, maybe I totally should have had you read it again, that we were restricting on-site consumption to these individual establishments that are selling medical now and also that are applying and that they're wishing to sell recreational, and that was it.
The motion, so the First Amendment, because this was the amendment of the amendment issue, the First Amendment was just to address on-site consumption for the non-conforming uses. Then Councilor Perry made an amendment to that which would strike all on-site consumption for anybody in the city. That was the amendment of the amendment. And so when that was adopted, that became the main amendment, which was then adopted, so then that became the amendment of the motion, which was adopted then, right now. Well, not adopted, but sent to public hearing.
Yeah, well, I don't know where we're at with amending amendments and where we're at. We're done. So we're going to hold public hearing and we're done. Okay. Gotcha.
Of
We
course, you
adjourn
do.
this
You
thing?
will have the ability to propose amendments at the public hearing as well.
We have to vote. We have to vote on this whole amendment. Yeah, we did. We still have.
No, that was the main motion.
Did we vote? We didn't vote on your.
Because the last amendment was to the time, and that was done. That vote was made, and so we were back on the main motion as amended.
So then we're
and
back on the motion that was amended now.
No, you just did the vote on the main motion as amended.
Oh, that was on the time. Okay.
Yeah.
You're
The
right.
city
we
clerk's got
already
it.
done that. Okay, I would just like to point out maybe a few issues you might think about before the next one is that where are we going to be? I mean, this basically is going to force anybody who wants to sell cannabis outside the city limits. They could have one of these smoke shop, smoke room. I mean, that's all, to me, I think you could force people outside the city limits just to look at that. So other than that, you know, wherever the city limits are, you might check on the ETZ about the authority we have to limit somebody's, if it's not in the city limits, I mean, this could be just like firearm things that aren't, you can't do inside the city, you can do it outside the, raising chickens, okay? I mean, you can do it outside. If you can't raise them in, you might be able to go outside and do it. So I'm just gonna say that's, so to look at that, so we have answers to that when we come back at the next hearing, when we come up to the next hearing that comes up, because we can still have amendments at the next hearing. So anybody who has amendments, I would hope we could get them done early, and please try to make sure they're, numbered, pages are numbered, so we can find, and lettered, so we can find them quickly.
Mayor,
Okay.
you'll be glad to know that you can bring your chickens from South Springs up into the city limits.
My dog ate all the chickens in South Springs. So.
I have chickens.
So, okay, Councilor Represa.
Mr. Mayor, before we adjourn, I would like to ask a question of Mr. Parker. It kind of is connected to this, but it really isn't. And it's a matter of reconsideration. How much time do we have in order to request an issue to be reconsidered?
As I recall the governing body rules, a matter on which the council has taken action may not be revisited for 6 months unless 5 councilors request in writing to the city clerk that a matter be reconsidered. That's, and I can double check that for you, but that's what I'm recalling off the top of my head from the governing body rules.
Okay, well, let me put it out there, and if we give 5 counselors to ask in writing for reconsideration, so be it. If not, I guess we'll have to wait for 6 months. But I would like to request to reconsider proposed ordinance 22-03, Article 52 of the City of Roswell zoning ordinance. And so if anybody is interested in having that reconsidered, I guess we can get a hold of City Clerk or the City Manager. I'm not sure who we have to ask for reconsideration.
Okay, I got it here. Let me read it to you. Agenda items previously considered and whereby action was taken by the governing body may not be placed on a future agenda for reconsideration within 6 months of such action unless requested in writing by 5 members of the governing body, provided that at least 1 member shall have been in the majority of those present and voting on the item.
And that one passed 10-0. So regardless of who was here or wasn't here, it really doesn't matter as long as one of the requesting parties
Was one of those original 10.
was one that was in the prevailing side.
Yes, sir.
Might I ask, what was that ordinance 23-52? What was it? Just
It is the, ordinance 2203, amending certain sections of Article 52 of the City of Roswell zoning ordinance. It talks about building height requirements, off-street parking, loading zones, and landscaping.
building heights, loading zones.
We just approved it in the March meeting.
Oh, the last meeting, is this the ordinance? This would be the ordinance that deals with buildings that I think they were talking about doing for downtown on Virginia?
Yes.
And the railroad
And I'm interested in bringing it back and talking about off-street parking. The one that I'm interested in.
Okay, so that's a motion that, if anybody's interested, please contact, Councilman or Presso.
In the interest of not having a rolling quorum, if you're interested, can you please just direct your comment directly to the city council, the
excuse
city
me.
clerk in writing?
In writing, okay, in writing to the clerk.
Right.
Yes, at least 5. 5, one of whom must have been one of the original. Only one of them needs to have been one of the originals.
Any further items come for you? Can we have a motion to adjourn? All those in favor signify by saying aye. Okay, the motion's adjourned.